Good morning. Thank you for joining our live webinar. Today's topic, child custody and child maintenance, Q&A. Good morning. I received a few questions from persons regarding this topic, and it seems to me that there is a need for a live Q&A at least once a week, whereby you can send us questions and we can deal with it live on our platform. We have a few questions. I'll get to it shortly. The way we'll be dealing with this webinar, if you wish to pose any questions, please do so on the Advocate Mohammed Abdullah Facebook page. I'll be keeping an eye on that specific page. So if there are any comments made, I will deal with it and I shall answer it. This specific webinar will be about, I don't know, about 15 to 30 minutes maximum. Therefore, if you have a question, please pose it as soon as possible. Sometimes there's a delay from the time you press enter to when it appears on my screen. I have 4 questions which has been posed already. How often can I apply for child maintenance increase? How long must I wait until I can apply for a reduction? Interesting question. What do I do if my child does not want to visit the father? Happens often. Who has a larger say over the child's life, the mother or the father? So those are the questions I'll be dealing with, and if there are any other questions, please leave a comment on the Advocate Mohammed Abdullah Facebook page and I will deal with that as well. Let's head into it immediately. Okay, the first question: how often can I apply for a child maintenance increase? So let's deal with the scenario. The parties would not come to an agreement regarding child maintenance for whatever reason, and one party approached the maintenance court. The maintenance court obviously had to do an inquiry, and the parties may have agreed to it as well. It happens often whereby parties do not wish to litigate child maintenance issues. They come to an agreement, a sensible agreement, and that specific agreement is made in order of court. That could be the one scenario where the parties approach a maintenance court, or one party approaches a maintenance court, and the maintenance court makes a maintenance order. So that's a date when the maintenance order was made. The other scenario could be whereby the parties where the parties got divorced, and the divorce court, either the magistrate's court or the high court, made a divorce order with a maintenance clause in it. So there's another scenario where a maintenance order has been made. And it happens sometimes where the children's courts make parenting plans in order of court, and inside the parenting plan there's also a maintenance provision. So those are the 3 potential scenarios. Now the maintenance order is made. The question which the questioner posed was, how often can I apply for child maintenance increase? Now, looking at that specific question, there's 2 legs to it. Number 1, the maintenance order was made, the party applied for child maintenance increase sometime thereafter. The question is, when can I apply for it again? Or if you are watching this video, another scenario which I'll be dealing with is how soon after the maintenance court made a maintenance order, an increase or a first order, can you apply for an increase? The long and the short of it is there is no specific date. That's very important to note. The moment there is a change in circumstances for either you, the applicant, the mother or the father, or in relation to the child, that justifies an application for an increase immediately. I'll give you a practical example. Let's say the child currently attends a school, and the specific school carries on from grade R right through to grade 12. Fine, the child is in that specific school. In grade 7, for argument's sake, something happens, the parties moves out of nowhere, they have to move to a different area, and now the child needs to change schools. School fees is much higher. Although the mother applied for maintenance a month ago, because of this new circumstances that arose, which causes the child to cost much more money, automatically there's a material change in circumstances, and the mother can apply, or the caregiver can apply to the maintenance court for an increase. Now, the maintenance court made an order stipulating that the father should pay more maintenance because there's a change in circumstances. They looked at his income, his expenditure, the mother as well, and the child, and they worked that amount. Okay, father, you need to pay more child maintenance because the child is attending a different school despite you've been at my doorstep 3 months ago where I dealt with this matter for an increase, but the issue regarding the change in the school was not on the table. Let us say, for argument's sake, going forward, the child attends a new school. For some or other reason, the father loses his job. He no longer can afford to pay the child maintenance or to pay a certain amount of child maintenance. Immediately then, he can apply to the maintenance court for a reduction. But that deals with the second question, which I will be dealing with shortly. And at the same time, should the mother, for argument's sake, under these circumstances, although she applied 3 months ago for an increase, the court granted it to her because the child cost more money. Last month, she applied for another increase because the child changed school. Now, all of a sudden, a month later, COVID-19 kicked in, she lost her job. Then she can apply for another increase in child maintenance. So there is no specific time period. I think you guys figure that out based upon my discourse. Nonetheless, if there is a change in circumstances, you are welcome to approach a maintenance court and they should be able to assist you. Let us deal with the second question, which I touched on a small bit early on. How long must I wait until I can apply for a reduction? Same principle applies, a reduction or an increase. So usually the reduction would be the person who is paying the child maintenance. If his or her circumstances have changed, even if the circumstances change regarding the other parent, for argument's sake, let us say the father is paying the child maintenance and he's happy with the amount and he can afford to pay the amount, but for some good reason the mother became extremely wealthy. Now the question is, must he still pay half his salary or quarter of his salary toward child maintenance, despite the mother being extremely wealthy, whereby she only spends not even 1% of her salary towards a minor child because she came across a lot of money? Those are material circumstances that causes and allows the father to approach a maintenance court soon and immediately, stipulating there has been a material change. The mother is not providing maintenance according to her means. Her means is much, much more. And also at the same time, it's not fair that I spend a third of my salary toward child maintenance, whereby the mother is extremely wealthy and she's paying much less. So under those circumstances, the father would have a case because there's a change of circumstances regarding the other parent. You will have to deal with the matter based on almost with the same situation. Let's say there is no maintenance order in place and the mother is super wealthy, the father is not so wealthy. Obviously, the court will make a reasonable order stipulating the father should pay a smaller amount. Therefore, when the father applies for a reduction based upon the fact that the mother is earning much more money, the court will have to look at this matter again, rework out the mathematics and what is a fair amount. And at the same time, should a child attend a very expensive school, during primary school for argument's sake, till grade 7, a very expensive school, and the father is paying half the school fees, but not directly to the school, a monetary amount, which is a globular figure, which is towards the maintenance of the child's school fees, clothing, food, accommodation, etc. Now the child goes to high school and she gets a bursary, whatever the case may be. The result thereof is that the child's education expenses are extremely low. She must only pay the registration fee and a small monthly fee, and that's it, compared to what they paid previously while the child was in primary school. Under those circumstances, because there is a material change in the mathematics, in the expenditure of the child, that causes the father to make an application to court for a reduction in the globular figure of maintenance which he has to pay. I hope that answered that specific question. So there is no time limit on whether or not you can make an application for an increase or a reduction in child maintenance. Please note, if you have any questions, feel free to leave a comment and I will deal with that. I shall deal with it. The next question deals with child custody. It goes as follows. What do I do if my child does not want to visit the father? Okay, there are two scenarios. Number one would be there is no court order in place, no children's court order in place, no divorce court order in place, which allows or affords the father care and contact rights to the minor child. If there is no such court order in place, that becomes a bit difficult for the father side. But let me deal with the other scenario. The other scenario will obviously be where there is a court order in place whereby the children's court or the divorce court specifically says that the father should have contact with a minor child every second weekend, half school holidays, birthdays, Father's Days, religious days, and so on. If there is no court order in place and the child does not want to visit the father, that is quite a concerning thing, because the question is, who's sitting in front of me? Is it the mother or the father? If it's a mother sitting in front of me, then I would advise the mother, please go to a professional person, a psychologist, a social worker, to determine why does the child not want to go to the father. Not based upon what the child is telling you. I do not want to go to dad, because whenever I go to dad, dad's other children are there. His stepmother is there, and I don't like them very much. I prefer to be at home playing PlayStation, being online, etc., because there's Wi-Fi and all the good stuff is here. But my dad is no swimming pool, and I prefer being here. Those could be the child's reasons. Are they good reasons? Are they long-term sufficient reasons for a child not to have any contact with her father? Because this is life. People move on with their lives. Or is the reason, no, I do not want to go to dad because whenever I'm a dad, they scold at me, they rude at me, etc. But that's what the child is saying. We need to get a professional person, a psychologist, social worker, to speak to the child and determine why does the child not want to go to the father? Are they cogent reasons? Are they good reasons? Are they the child acting up? Child playing against both parents? Is it silly reasons? That's what needs to be determined. So the expert will have to speak to the minor child, speak to the father, speak to the mother, and try to resolve the issue. What is in the child's best interest? Is it in the child's best interest to stay by the mom, watch TV games, screen time, and have no contact with the father? And 5 years down the line, when the child is older, she moved away from her dad, and they just became, estranged from each other. Is that in the child's best interest, or is it would it be in the child's best interest if the father tweaks some of his behavior, the mother tweaks some of her behavior, the child does the same, and they try to resolve this matter? So that's a scenario whereby the parents have no order in place. The expert will hopefully try to assist the parents in trying to resolve this matter. Why does the child not want to go there? That's now where the mother is in front of me. If the expert says, no, mom, I think it's best for the child not to visit the dad because of X, Y, and Z, and this is my report, and if that report needs to be seen to the father, and the father needs to come to terms with that, and hopefully the father will work towards the recommendations in the specific report. If the expert recommends, no, child, you need to go to the dad, there's nothing cogent in what you are saying, you're just being unreasonable, like any child might be under those circumstances, and then the mother should cooperate and work towards the father having contact. If the father is in front of me and he tells me the child does not want to have contact with me, then I would also follow that specific route and stipulating, get a third party on board to investigate, to speak to the minor child and find out what the reasons are. If the child does not, if the expert, who gets on board, states that it's best for the child not have contact, or contact should be limited, or contact should be this or that or that, the father needs to take note of that, and the father needs to work towards fixing things so that contact can be regular and back to normal. If the expert stipulates that the father should have contact and the child is acting out, as I mentioned earlier on, and the mother does not agree to that, then unfortunately the father will have to take this matter to court, and the court will have to determine what is in the minor child's best interest. One step before that could be trying to mediate the matter, but in my view, usually if there's a social work involved, they speak to the parties, they try to resolve matters. That is, in any event, a type of mediation. But nonetheless, each case is different, and the tools available will apply differently to various people. But I always recommend mediation. It must be somewhere in the equation, and also getting a professional on board, an independent professional person on board, to assist the parties in trying to resolve these specific matters. Okay, I have a question, a live question. It goes as follows. What if the father dies and he must still pay the maintenance? If the father passes away and the minor child requires maintenance, a claim can be made against the estate of the father. That gets preference over other claims. So if the father passes away and the minor child requires maintenance, you need to speak to the executor of the estate of the father, and a claim should be lodged for maintenance for the minor child from the estate. I hope that assists you, And people need to do that. People need to know that if somebody passes away, you can file a claim for child maintenance against a state or the deceased party. That was a live question. If anybody else has additional questions, feel free to pose it and I'll try my best to answer it. I hope I answered that question correctly. And the last question from a previous three questions, put it that way. Who has a larger say over the child's life, the mother or the father? Interesting question. And a question which is sometimes difficult to answer in isolation. Sometimes you'd want to have some facts in front of you, a scenario, background information. Child with a mom, child with a dad, they broke up, they're divorced. The child is 12 years old, the child lives 10 kilometers from the mom. So those are the data which I would prefer to have in answering these specific questions. But if a party has parental rights and responsibilities over a minor child, then he or she has exactly the same rights and authority and power as other parents. So the mom and dad have equal say in the minor child. I'll make it easy for you. Either parties are married, done, full stop. Both have equal rights regarding the minor child. No one has a greater say. Obviously, as human beings are, and we expect parents to be reasonable. If they have a discussion regarding what school the child should go to, they should be reasonable, and the mother might know better because she's done the research. So the parties needs to come to an agreement the same way as mom and dad who lives in the same home. Let's say they are married, and then are having discussions regarding the child. The father doesn't say, I have a greater say over the child's life. Or the mother says, I'm the mother, I'm the biological mother, I have a greater say over the child's life over you. That doesn't work that way. You guys need to come to an agreement and work together regarding what's in the minor child's best interest. If you cannot come to that agreement, unfortunately, my advice, as I mentioned earlier on, get a professional on board to try to assist you regarding what's best for the minor child. Try to mediate this matter. If the matter is so serious, for example, which school the child should go to next year. And those are complicated matters because how does a judge know? How does the magistrate know? How do I know as a lawyer what school will be best for the minor child? I can presume, for example, if I like soccer, would that mean that school will be better for the minor child? If I do not like tennis, would it mean a school that has tennis is not as good for the minor child? Whatever the case may be. So speak to a professional, get somebody on board, try to mediate this matter. There are various factors applicable, for example, school fees, location, what the child want to become when he or she is older, the child's grades, etc. We are going to with a scenario in isolation. The parties need to discuss these matters because a mother does not have more rights over the child than a father. There can be scenarios where the mother does have rights. For example, if the father was not married to the mother and he made the mother pregnant and went missing, of course the mother has more rights over the child than the father. But if the father was involved in the child's life since birth, automatically he acquires those rights. And he has just as much rights over the child as the father, as the mother, my apologies. However, if there is a dispute and the parties cannot come to an agreement regarding what is in the child's best interest, the matter will unfortunately have to go to court, and the court will ultimately have to determine what is in the minor child's best interest. Okay, that deals with those 4 questions I have and the live question which was posed. If there are not any additional questions, I will take it as this video should come to an end. And I'll thank you for your time. I hope you have a lovely week ahead and hope to see you online soon. Thank you very much.